We have to talk about this United States Supreme Court of Murthy versus Missouri, which deals with the First Amendment and social media companies like Facebook and others, and whether or not, let's just say, encouragement from the federal government to censor certain information or promote other information, whether or not this has First Amendment implications. We're going to talk all about this Murthy versus Missouri case because a lot of people have asked me about this on X and down below in the comments for my videos here on the Four Boxes Diner. So let's talk about what this means. It's complicated, but I'll break it down so you understand and will be the smartest person in the room because of it. Stay tuned. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of the brand new best-selling book, Israel Disarmed: What the 10/7 Attacks Teach Americans About the Right to Bear Arms. Check it out on Amazon if you have not already done so. And if you've already bought the book and read it, feel free to leave a review there on Amazon. That's always helpful to show interest in the book. I'd appreciate that. All right, folks. So I've gotten a lot of questions about this big social media First Amendment case called Murthy versus Missouri. And I'm going to break this down for you in a very easy to understand way. I'm not going to get into too many of the weeds or the details because I don't think it's necessary. And yes, I'm in a suit because another Fox News day. If I'm in a suit, you can basically assume that I had some Fox News obligations, something like that. So I'm sure you'll be talking to me also on TV in addition to the YouTube channels for the next many months because we got a lot going on with this presidential election, a lot of fallout from that debate. So a lot of commentary on that and the Supreme Court and more. Okay, folks, so let's talk about this Murthy versus Missouri case. Now, put this into context. You have the federal government, which is the government. The reason why I say that is because it's important to First Amendment. Remember, the U.S. Constitution and the Bill of Rights is about limiting, restricting, stopping the growth of government, right? So the First Amendment is designed to prevent government from doing bad things to our right to free speech, okay? Then you have social media companies, the X's of the world, the Facebooks or the Metas of the world. These are private companies. They're not government. They're private companies. And therefore, the First Amendment, the Second Amendment, the Bill of Rights, as a general matter, does not apply to them, which means a private actor can violate your First Amendment rights as a general matter because, again, the First Amendment doesn't speak to private conduct. It speaks to restricting government conduct. Now, here's where the rubber meets the road in the context of Murthy versus Missouri and the First Amendment. That is, if the federal government basically deputizes or designates or coerces private individuals or private parties to do the bidding of the government, it becomes a little bit more fuzzy as to what's going on here, right? So if the federal government makes a private actor, a social media company, makes the private actor censor, let's say, you, or take away your Second Amendment rights, let's say, then there's an argument that the government, through a private agent or private designee, has effectively violated your First Amendment rights. We'll talk about the First Amendment because that's what Murthy's involved. So we'll talk about the First Amendment right to free speech. They are violating your First Amendment speech because the government is acting through social media companies. Now, in the context of what's going on here factually, all the issues in this Murthy versus Missouri case arose after Joe Biden took office in 2021. You had the Surgeon General Murthy, who, by the way, is the same Surgeon General that just announced that gun control is a national disease, or I should say that guns are a natural disease and we need gun control. What a total moron, right? Can't believe he's a Surgeon General. Just embarrassing. Nevertheless, we'll talk about that on a different video. But again, obviously, a lot of these people get elevated to very high levels in the government, and it doesn't appear to be anything to do with competency, but I guess you don't have to be competent in government because there's no accountability. You can be the biggest moron on the planet and you can still get a job with the government because no one's going to fire you, right? Because you're working for the government. In fact, in some ways, government encourages inefficiency and ineffectiveness because it encourages more and more government to fix a problem that they caused. But again, let's not talk about the problems with government in this video. Let's just turn to the fact that the same Murthy that came out that says guns are the problem and is a national crisis and all the nonsense, it's the same Murthy that was sued in the context of this Murthy versus Missouri case, just to connect the dots for you. So anyway, the Surgeon General here, Murthy, basically was urging social media companies to take down COVID information that they didn't like, that they thought was disinformation or misinformation. For example, anyone that was discouraging people from taking the vaccinations, guess what? They would encourage people to take down that information. Now, the way to understand the dynamic here, as alleged and as was found by the lower courts, is you have the federal government and you have the social media companies. And then you have another group, which is the people that are actually directly impacted, meaning the people that were doing the post. So you really have sort of three things going on here, or three parties you need to understand. It's not that hard, but the three parties to understand. You had the government, you had social media companies, and then you had the individual Americans expressing their First Amendment views on those social media companies. And what was allegedly occurring and what was found by the lower courts is that the government was putting pressure on the social media companies to basically moderation policies, to take down posts of individual Americans that the government didn't like. And there was this sort of coordination going on between the government and the social media companies to oppress and censor certain speech that the government didn't like. And the social media companies were doing the bidding of the government. And now, if you think about it for a second, what was arguably going on here, and this is what the lower courts basically found, it's like the mafia or organized criminals. So you run a restaurant somewhere, and next thing you know, somebody from the organized crime syndicates come up to you and says, geez, that's a really nice restaurant you're running. That's a really nice window you've got there. It's very beautiful. It would be a shame if something terrible happened to your restaurant and put you out of business, or made you have to replace that window every week. But I've got a great idea to make sure that doesn't happen, if you know what I'm saying. Maybe you should, use my buddy here to do all your trash hauling. That would be super cool, right? Then we can be win-win-win. You get the point? So obviously that's not necessarily an express threat that we're going to break your window every single week if you don't use my brother-in-law to do your trash hauling, but that's the notion. It's implied. And what the argument here was is the federal government was going to the social media companies and they were basically saying kind of one of three things. And this is what the dissent of Sam Alito said, and then we'll talk about the holding in a second, but I want you to understand the context before we talk about what the court found. So basically what the dissent in this case from Justice Alito, Justice Thomas, and Justice Gorsuch were saying is, look, the federal government has a lot of power and suasion over these social media companies. For example, you have this thing called Section 230 that says social media companies as a general matter cannot be sued for content posted on their websites that they don't control. And that statute could disappear or might not be enforced or whatever. So that's one sort of area where the government could say, well, we're going to try to repeal Section 230 and then you'll be in big trouble. There's also, of course, antitrust laws. There were references here that the federal government indicated that these social media companies were subject to antitrust rules. So again, if the social media companies did not behave, well, the Biden administration might threaten them and go after them with antitrust violations to try to break them up or punish them in some way. So another sort of hint, you don't want your nice window in the front of the restaurant getting broken, do you, sir? Maybe you should use my brother to do the trash hauling kind of concept here, except the federal government was saying, hey, you know what? We don't really want to bring this antitrust case against you. That would be terrible. So maybe you should just work with us on this social media stuff and make sure that we censor the bad information for public health reasons. Hint, hint, nod, nod. Get the point? So that's kind of what was allegedly going on here and what the lower courts found. And of course, the federal government is very important for protecting international markets. So when the Europeans want to mess with our American companies, whether it be Meta or whatever, then the federal government is able to, pick up the phone and call the president of France and maybe work out a deal so it all works out in the end. So again, the idea of the federal government having tremendous ability to sway and influence these social media companies is obvious, and the social media companies are not naive. So what happened in this case? So with that said, what happened in the case? Now, here is the problem. In a 6-3 decision, the Supreme Court ruled that there's no standing on the part of the plaintiffs. Now, remember, I've taught you this before. There's two areas of law. There's substantive law, like what does the First Amendment mean? What does the Second Amendment mean? That's substantive law. But then you have something that's equally important, and I've been hammering this home so you really understand it. The process and the procedure whereby a case goes womb to tomb through a system, from the start of a case to the time you're put in prison, from the start of the case to the end of the lawsuit, whatever it is, womb to tomb. That's the process. Now, the reason why this comes up is here's an example where the process got messed up. I'm not saying it's anybody's fault. I'm not even saying it got messed up. But the Supreme Court 6-3, the majority opinion, said that there was no standing on the part of the plaintiffs in this case to get an injunction, because they could not trace their injury to these activities. And I think what the majority was really trying to get at is to say that the activities that the plaintiffs are complaining about back years ago are no longer true today. I think that's kind of where they're getting at. But the bottom line is 6-3, the 6 Supreme Court justices, in a decision written by Justice Amy Coney Barrett, said that the plaintiffs were not able to trace, which simply means to connect the dots or to show causation, between the government conduct on the one hand and the injuries to the individual plaintiffs on the other hand. Now, the three-justice dissent written by Justice Alito with the support of Justice Thomas and Justice Gorsuch says that's basically BS, that the 6 justices are intentionally trying to dodge ruling on the substance of the law of the First Amendment and the fact that the federal government was obviously doing this kind of moral suasion or this coercion campaign, this jawboning campaign, using their authority over social media to make sure the social media companies did what the government wanted, to punish and injure and censor Americans who had First Amendment rights to speak on various issues such as COVID. So with that said, that is what the fight is about. So the three justices in dissent said, we not only think they're standing here because the plaintiffs have already shown standing because they've been injured and there's been findings that they were injured by the lower courts. Beyond that, the court, they think that the 6 justices just don't want to deal with this First Amendment issue because it's a little messy. But the 6 justices say, look, there has to be standing because under Article 3 of the U.S. Constitution, we can only sit over cases and controversies. That requires there to be a standing issue, meaning that the plaintiff can show that he or her has been injured by the conduct of the defendants, and that the court can redress this in some way, either through monetary payment or an injunctive relief going forward. And the dissent said this is clearly satisfied here. Now, one of the things that's going on here is that the 6 justices are basically saying that the connection between the government action and the punishment or injury from the censorship by the plaintiffs is too attenuated, is because they're saying the social media companies seem to be going along with it and seem to want to do it. So they were really doing what they wanted to do anyway. It wasn't that the government was causing the social media companies to do this. The social media companies wanted to censor these people, and because they're private actors, remember what I said, the First Amendment doesn't protect you against private actors, and the argument is because they're private actors, they were allowed to censor, and there was no showing of causation that the government was making or threatening the social media companies to do this. The social media companies were doing it on their own, and therefore there's no causal connection between the government on the one hand to the ultimate people that paid the price that were censored, meaning the people whose posts about COVID were taken down. And therefore, that private social media company in between the government on the one hand and the posts getting taken down, hurting the individual Americans on the other, they're saying that that is too attenuated. And because there's no trace or causal connection there, there's no standing for those plaintiffs to be able to sue ultimately the federal government for this conduct. Now, the dissent totally disagreed with this. Now, I will just say one thing. Anytime you litigate a conspiracy case or something that occurs behind closed doors, it could be a criminal conspiracy, it could be secret antitrust conduct going on, of restraint of trade, whatever it is. Obviously, it's very hard to find a smoking gun because it's being done in secret, right? Conspiracies are done in secret. So anyway, that's kind of the gist of it, folks. Obviously, there can be future First Amendment challenges in this kind of conduct, but this case looked pretty strong. There was a lot of evidence of this coercion and relationship between the government and the social media companies in all of this stuff. But, I encourage you to read the dissent and the majority opinion and see what you think. But again, when I talk to you about the importance of process and procedure, such as standing, case, and controversy, it sounds really geeky and nerdy, and it is, but it's important to understand not just the substance of the First Amendment, the substance of Second Amendment law, but also the process and procedures whereby these cases get through the system, whereby the sausage is made. And I'm trying to teach you both, so you will be the smartest person in the room, and you'll go forth and defend our rights in your communities. That is my goal, to force multiply what I have in my head with all you out there, so you can go out there and again, defend our great country and our great Constitution. So there you have it, folks. Hope you learned a little bit something here today. Don't forget to put some quotes or questions or comments down below. Criticisms, feel free to do so. Make sure you subscribe. Don't forget to follow me on X at 4 Boxes Diner, and we will see you again soon here at the 4 Boxes Diner.
Orders up. Table 2A.